Hi, everyone. I am here to talk to you about some of the major issues in applying the Constitution. I have my little son Josiah here on my lap. Turned out to be the best time to record. It was also when it would be helpful to have him on my lap. So, a couple things I wanted to say as we introduce the idea of interpreting, applying the Constitution. I'll have more to say in class on Wednesday, but the first thing is that with the putting in place of the Constitution, there was the question of the Bill of Rights. The Federalists in the late 1700s, the ones who had wanted the Constitution to be in place, had said there really was not a need for a Bill of Rights because the government was not given power to legislate in the areas of things like freedom of speech, of freedom of religion, um, jury trials, things like that. Okay. And so listing rights would actually limit them because then people could argue, well, it's not in the Bill of Rights, so we can do it. Okay. Those rights can be limited. The Anti-Federalists, on the other hand, said, no, we don't trust the government to limit itself to that. Josiah's seeing his picture here. We don't trust the government to limit itself, right? So we need these rights enumerated. That argument won the day. The Bill of Rights was adopted. The first 10 amendments to the Constitution were adopted by 1791. Okay, and that meant that the famous Bill of Rights, the first through 10th amendments, were indeed adopted. Now, the next big question in the early 1790s, the years after the Constitution, was basically a strict interpretation of the powers of Congress and the federal government, or a looser interpretation. Sometimes you call this strict construction versus loose construction. And Alexander Hamilton is the most famous proponent in the early days of the loose construction. And the basic idea is that if Congress needs it to advance the country based on the implied or the listed powers in Article 1, it can be done. Okay. He was a major proponent of national strengthening. Okay. And so he wanted things like a manufacturing incentives by the federal government. He wanted a national bank. Okay. And he thought the best way to secure the future of the United States is to have a powerful federal government that's close with the business community and with banking, because there's simply no other way for a government to have a secure financing to be able to finance its military, things like that. Okay. On the other hand, you had people like, say, James Madison and Thomas Jefferson, who said the government is too powerful under that interpretation, so we need to have a stricter construction. Only if it's in the Constitution or very closely tied to the constitutional powers can we have a sort of congressional actions. Okay, and so they thought Alexander Hamilton was creating a monster. Okay, he's creating this powerful federal government, a national bank that's going to be corrupt, and it's going to be this unholy alliance of industry and finance and government. It's going to create a tyranny. Alexander Hamilton's looking at Madison and Jefferson and thinking, they want this tiny, weak little country. We've got to be able to compete with the big boys like Britain. Okay. And so that's an enduring controversy. Do you want a powerful federal government? Do you trust that more? Do you like the idea of a federal government that takes strong leadership of the nation? Or do you trust more state authorities and a limited federal government? Okay. And it doesn't really make sense to call Alexander Hamilton and Jefferson and Madison liberals and conservatives in the same way we think of today. But some of those same issues are still right here in our country today. All right. Now, that's a big question. Now, the bank is created. A lot of the anti-Hamiltonians, what are called the Democratic Republicans, don't like it. The Hamiltonian Party or the Federalists do like it. And a really important Supreme Court case, it's talked about in your book, is McCulloch versus Maryland. This is in chapter 2 in the chapter on federalism. And Maryland had tried to make life difficult for the Bank of the United States, by taxing its office there in Maryland. Okay, the Maryland government wanted to do that. And John Marshall, who was a Federalist and the Chief Justice of the Supreme Court, the same one who had declared the power of judicial review, said, no, you can't do that. This is a federal institution, not subject to the states. The federal government is supreme over the states. And Congress clearly has the right to create a bank if it wants to. It is carrying into effect the powers that it has. It's not against the Constitution. It's clearly part of what Congress has to do based on those enumerated powers. So it's clearly constitutional. You don't have to have a line in the Constitution, basically he's saying, that says Congress can create a national bank. And if Maryland can tax that bank, it can destroy the bank. So Maryland, you can't tax the bank. Okay, and that's a clear victory for the kind of national conception, a strong federal government conception of the federal government's power. All right. But still, compared to today, the federal government didn't do an awful lot. And that's why your authors of the book, Turner and the others, talk about dual federalism. This is fairly common for much of the country's history. You have something like a dual federalism where the federal government has its sphere of national taxation, of military maintenance, of regulating interstate commerce to some degree, but the states have a lot of authority in their realm. Okay, that's called dual federalism. It's sometimes compared to a layer cake, okay, a chocolate and a vanilla on separate levels, okay. But with the New Deal, which is the program that Franklin Roosevelt and his allies in the Democratic Party in the 1930s come up with to try to get out of the Great Depression and make the country more fair according to their view of things, that really initiates the glory years of what's called cooperative federalism, okay, where the federal government says, all right, we're going to take the lead in things like Social Security, in all sorts of different welfare programs, things like that, later on Medicaid. But we're going to give the states some role in that. We're going to give them money, and we're going to tell them that they have to use it for these things. It's incidentally a pretty good way to build loyalty in those states when officials realize, yeah, we're going to get lots of money. But that idea here is clearly the federal government in the driver's seat. And so that's sometimes talked about as a marble cake, okay, chocolate and vanilla mixed together. So that's cooperative federalism. New federalism was talked about at the very beginning of your chapter. I think you could think of it more in terms of a dual to cooperative. After the Great Society period, 1960s, the high watermark of cooperative federalism and a strong federal government, you start to have a more conservative turn to some degree, or at least more conservative ideas getting more influential than they had been before. And that's with Richard Nixon and later Ronald Reagan. And new federalism tends to say, all right, federal government is going to supply the money. The states get more choice in how to use it through things like block grants. Okay, so here's the money for this anti-poverty program. You guys figure out how to use it. Okay, that's a more conservative approach in a sense, or a more states' rights type of approach, because it allows states to do things as they see fit a bit more. Okay. And then in the 21st century, you have what's called sometimes progressive federalism. And this is both in the George W. Bush and Barack Obama administrations. Okay. And especially the Obama administration, but Maroney and Kirsch, some other authors say that they're basically building on sort of what George W. Bush did. And that's where, in progressive federalism, the states are allowed to choose different means, but the federal government sets the goal. Okay, so you had this with education, with No Child Left Behind. The George W. Bush administration wants to get more students doing better in reading and math, okay? But not always saying, here's how you do it. Okay? And so the No Child Left Behind sets the goals, but not the ways to get there. States have to develop their tests and everything. And that's, something of a controversial program. Not too many people these days are saying, oh, No Child Left Behind, how wonderful. But the goal of it was something probably most people can get behind, which was not allowing districts to kind of say, well, our kids are poor, and so they're not going to do very well. What they really wanted to do was to get all districts performing well. Again, controversial. I'm not a huge fan of the way that was done, but I do like the goal. And again, you can probably understand why there were goals like that to try to raise the standards. Okay. Another example under the Obama administration was Race to the Top. It's kind of revamped No Child Left Behind. And then we have also the healthcare program, Obamacare, Affordable Healthcare and Patient Protection Act, which said we want to get to something like universal healthcare. Everybody's got to buy it, but the states set up their own exchanges if they want to. Okay. Sorry, not if they want to. They were supposed to, and then the states won the right not to at the Supreme Court. But it was a idea anyway that the states would set them up, and so the federal government had to do it if they didn't do it. All right. So these were some examples of cooperative federalism. All right, and that we'll see, where that goes from here. But those are some of the different models of federalism. Okay. Now, that's your book does a really nice job, very thorough on federalism. Okay. And so that's always a good to make sure you're reading that, trying to understand it. I'm glad to answer questions. On civil rights and civil liberties, this raises some of the same questions. Again, goes back to the Bill of Rights. Also, how are our rights guaranteed? And the key moment in history here, in the changing of civil rights and civil liberties, is the Civil War and Reconstruction. Okay, Civil War and Reconstruction, which is the great war between the states, war over slavery and expansion of slavery, all that kind of stuff. The 14th Amendment is the key amendment here, and secondarily the 15th, because the 14th Amendment says that all people are citizens first, really, of the federal government, or of the United States. It defines citizenship at the federal level. All people born or naturalized in the United States are citizens of the United States, instead of allowing the states to define citizenship. Another really important thing is it says that all people get equal protection of the laws. Okay. And third, it also says that people have the right to not lose their life, liberty, or property based on due process. They have to have due process first.
I need a video.
You see the video, Sabrina? Yep.
I need a video.
Yeah. Okay. You can watch. Now, the due process of law means that you have to follow certain things, but it's not really spelled out in the amendment. Okay. Now, what was that meant to do? We can get into all sorts of debates about that, but it's not really applied to the states until the 20th century, the mid 20th century, basically. Okay. And the idea here is what's called selective incorporation. Okay. The incorporation of the Bill of Rights to the states through the 14th Amendment. I'll talk about this more in class on Wednesday, but the basic idea is the Supreme Court, as it continues to get cases sent there, Sabrina, as it continues to get cases like Brown versus Board of Education, it's going to say equal protection of the laws means that students can't be segregated based on race. Okay. That equal protection of the laws ultimately is going to mean that free speech applies to people at the state level and not just at the federal level. Okay. Equal protection of the laws means that people also have the right to attorneys when they're in state court. They also have the right to all many of the things in the Bill of Rights in the states and not just when they're in federal court. Okay, that's what we refer to as selective incorporation. As the rights in the Bill of Rights kind of case by case get applied to the federal government. Okay, I'm sorry, case by case they get applied to the states. And I'm going to do a part 2 in just a few minutes.